The SIEL conference hold every 2 years, and actually it's a very competitive process for applying to host such conference. So when we noticed that this is this very precious chance for us to be able to hold such international conference in Taiwan, so a bunch of scholars from Taiwan just come up with an idea that we will submit a panel focusing on Taiwan's role in the changing landscape of global trade. So this is the original idea that we would like to compose 4 papers. I think that we will have 4 panelists that going to discuss some of the issues that are related to Taiwan. Okay, and some will be regarding trade remedies and dispute settlement, as well as gender issues. But for one thing that I would like to highlight is that given that the call for proposal actually happens almost 8 years ago, so if you think about last year, this period of time, actually is the Taiwan played a very crucial role. Actually, we just concluded the trade agreement with the Biden administration regarding the 21st century trade agreement. But as you all know, that the things change pretty fast, right? After Trump being elected as a president, and this year we no longer talk about that trade agreement anymore, as well as the IPAF, no longer being so important under Trump's administration. So originally, we would like to talk about the significant role of Taiwan that to be played in this global trade arena. But right now we have to adjust for some kind of the trend has been changed, situation different. So one of our panelists has to change the title of the paper later. She will discuss it later. So in any event, I think that as we already talked about the semiconductor industry this morning, and you all know that Taiwan played a very crucial role in the supply chain of technology. So I think that still we can have some discussions regarding how Taiwan can be placed in the role during the in the global trade pattern. And I forgot to introduce myself as Pei-Kan, and I also teach international trade law at the National Chengchi University. And today we are going to have 4 panelists. And starting from my left hand will be Nan-Hsun Chang, is from Soochow University, and Huang Brookes University from UK. Sorry, Ching-Wen and Huang and Hsien. Okay, so later he also can introduce himself, and basically we all Taiwanese. Okay, one of us teach in UK, but still Taiwanese person. Okay, so in event, their topics will going through the sequence will be a little bit changed. So first presentation, we will invite Huang to present her articles, and then Professor Zhang Nan-Hsun, and then Ching-Wen Hsien, and the final will be Hsien. Okay, so without further ado, I think that each one of them will have at most 15 minutes of presentation, and they may end up with 10 minutes, and hopefully that we can gather some of the questions and ideas, any comment, so that we will leave the Q&A toward the end of the presentation. So we will not interrupt their presentation. We will present in this order sequence, so that after 4 presentations, then we will come up with the discussion Q&A section. Okay, so is that okay for you? Then please give us a great round of applause for welcoming Huang to present her article. Thank you very much.
Thanks, everyone. I'm Chieh from Oxford Brookes University. I'm a senior lecturer in law, so I teach WTO, transnational law, international business, transaction, and etc. So my research is therefore more, going along the line between the cross, between public and private sectors. Here, I'm presenting a paper that is a result of collaborative research projects with Dr. Chang here, that she's going to talk about something related but different. So my topic is really trying to look at the international trade barrier investigation process. So I believe that for most of us, if you study or research on international economic law for long, you realize that the private actors or business are the parties who has a much strong feeling or impact of any trade barriers or unfair trade practices, if you want to label it as unfair. However, in the current international legal system, especially like dispute settlement like WTO, only states will have the standing in the dispute settlement forum. So it's inherently important for each country to have certain mechanisms, certain channels to allow the private interests to be reported, to be informed to the government. So the government, the state will be able to take certain actions in international forum. So that is really the core sort of underpinning concerns when we talk about these private public collaboration in terms of international economic law. So these issues are getting even more sort of concerning or more important after the creation of the WTO, as we all know that the legalization tendency of the WTO, the dispute settlement procedures requiring more and more data, legal information, and those evidence put tremendous pressures on the government for the collection of data, information, as well as financial resources sometimes, won't be able to cope with the procedures. And that is debated by Professor Schaffer this morning, that the need for the enhanced public-private collaboration. Okay, so we see that at least scholars anticipate there need to be closer and closer, collaboration between the private and public sectors. And to answer that, we can see that on the domestic, legal structures, you often have several pathways for private, sectors to channel their interests, their concerns to the government. If those negative impacts of foreign products occurred in the domestic market, that we are familiar with those, our respondents. For example, we have anti-dumping duty investigations, we have countervailing duties against subsidies. So those mechanisms are very well developed under the WTO agreements as well as in the domestic law. However, looking at arguably most important functions of WTO is market access, right? So if you have any trade obstacles impeding your market access in a foreign market, on there we don't really have a very clear, well-defined mechanism under the WTO agreements or in most of the countries' domestic legislation. So this is the part that will be for my focus of presentation today. That is the trade barrier investigations, and very often that we will see informal trade barrier investigations existing around the world rather than formal law or legislations on this part. Okay, so okay, that's to highlight what I'm going to focus on. Okay, so what is trade barrier investigation? So basically that is a kind of a mechanism that at its core, there are two goals. First, to confirm whether or not foreign measures really amounts to trade barrier, And secondly, you need to decide on certain reaction upon these foreign measures. Are we going to do something? Are we going to or ignore or dismiss that as not a serious or not a genuine trade barriers? So trade barrier investigations is to serve this purpose. And the function will have certain procedures to identify barriers, provide information, allowing the private actors to provide information, evidence, and carry out initial investigations, and then end up with a certain decision what the state will do in response to those allegations of trade barriers. However, okay, in the literature, obviously, we emphasize how important those channels are, how serious that we should listen to the private sectors as a government, and we should base our decision makings on the information collected. However, in the world, only very, very few countries have specialized legislation or procedure within domestic legislature. So we know that the Section 301 in the United States, we know the EU TBR, and also, of course, as Taiwanese, we experience the foreign trade barrier investigations initiated by China. So from our research, on the literature, we didn't identify or find or locate any other countries having those formal legislations to enable private actors, initiate the trade barrier investigation. So obviously, our next question is why? Yeah. So if I can stop, on my question by looking at what we mean by formal trade barrier investigation, then we are often identify countries with the formal investigation mechanism by having one that provide a legal basis in their domestic law. You will also in the in the domestic law, in the legislations, to identify very clearly how the investigation can initiate, who will have the power to initiate the investigation, and what will qualify these private actors to represent, either the business associations or the sectors to initiate such a procedure. Then there is a very well-defined and structured investigation process, and embedded in the process very often will be the remedies available to the private actors and require response, either the time frame or certain response from the state. Then the final part will also have a wide range of options provided to the states as to how I can make my decisions on these petitions, as well as what kind of available actions I might be able to take. Okay. And however, in practice, we will see that in the recent literature as well as our comparative study, that not the formal mechanisms, even in the US or EU, have never been really the main channel for private economic entities to report trade barriers. So if you are big companies like TSMC, you pick up a phone call to call your call the trade representative, or you report your issues to those people sitting in legislative yuan. And we through the empirical studies that we searched and studied and found that actually several factors stop private actors from using this mechanism. The first one, obviously, is the heavy burden to initiate the procedure, because it's legalized, because it requires a certain level of evidence to support your case. It make if you are a big company with a big law department, that might be nothing big issues. However, for smaller enterprises, that is often a cost that is high enough to stop them from even considering this route to report trade barriers. And the whole process often takes too long. So if you are encountering certain issues of marking assets, you don't want to wait for months or sometimes more than a year for the government to consider your petitions and take actions against those trade barriers. And in the very recent published paper, Professor Chieh and Hsueh also highlight this particular trend of not using those formal mechanisms for reporting trade investigation, but rather a general tendency for those governments, actually only 3 countries, to especially US and China, to use these trade investigation as rationale, as a tool to actually initiate some strategic economic policies or extraterritorial quantitative restrictions. So they kind of describe these trend as normative reliance, alignment. Yeah. So on the other hand, so if a country have no such formal mechanisms, it doesn't mean that there is no channel. Yeah. So very often it can be ad hoc responses to business concerns. However, from our study, we realized that several countries do have certain institutionalized procedure or mechanism, although not based on law, although not provide specific procedures or states or grant particular rights to private actors. We do have that. So that is our focus of Taiwan as a case study. So for Taiwan, how the government to know or to be aware of the trade market access issues faced by the private sectors, they are generally these top-down surveys carried out every year. So there's annual surveys are inviting private sectors to report the trade obstacles they faced in foreign market. And however, these surveys are not usually directly targeted at private actors or companies as such. However, they are often dispensed through the trade or business associations. And there's also publications of trade barrier reports, every year summarizing, what kind of issues the Taiwanese sectors faced. And there's, in addition, parallel to that, separately on particular technical standards issues, there's also a notification systems or mechanisms, passing through sort of outsource research institute to reach to the private sectors. The problem is that if you look at the private sectors, they do have pathways to reach to the state. However, they never have rights to request any investigation as to the existence of the trade barriers. They don't receive response. They don't know what happened after they report, such trade barriers. So that is often the issues leading to the conclusions during our interview. Very often, voiced by the private sectors that is that really useful? Yeah, we don't know, what happened, if we report these trade barriers. So my concluding, slide is that are we suggesting Taiwan moving to formal mechanism? Maybe not as such, as we can already see that the formal mechanisms are actually not widespread or even a popular, framework for the private sectors to report the trade barriers. However, there are certain benefits of this formal mechanism that we can probably capture and refine our own semi-formal system. So first of all, legitimacy in policy making always require the participation of the public opinions, and also providing transparent procedures leading or allowing the private actors to know what happened, to their reports will be a very important step to sort of enhance the trust of the private actors to use such a system. And there need to be certain rights to private actors, either the rights to petitions or the rights to require for the review or recheck, or at least certain reasons for the rejections or denial of such or dismiss of such petition. So we are suggesting probably certain online database such as the EU practice might be a good way forward for the Taiwanese government to consider in responding to the very fast changing international trade community or world. Okay, that's the end of my presentation.
Thank you. So shall we just move on to the next presenter, Nan-Hsun, Chang? Thank you.
Okay, ladies and gentlemen, I want you to check out this chart. As the main target of the anti-dumping investigation, just behind China and India and Korea. We know any change in the anti-dumping or countervailing duty law will affect our industry significantly. That is why I want to follow the recent United States amendment of the AD and CVD regulation and think about how our industry to cope with this influence. And in both anti-dumping and countervailing measures, the benchmark price is critical to determine the dumping and the subsidy and also set the duty rates. And dumping occurs when the product is sold below the normal value, which refers to the exporting country's domestic prices. And the subsidy exists when the government provides provide order or purchase goods and service without adequate reward. And the domestic price in the exporting country are presumed to be to reflect the fair value unless distorted by particular market situation. But however, the social or environment standard, which we will call it the sustainability standards, can affect the production cost, raising the question of the comparability of the domestic prices. In 2024, last year, the United States passed the AD and the CVD amendment to target unfair advantages from the weak sustainable enforcements. This is a quite big change in the AD and CVD laws. It's shifting from the traditional dumping and social concepts to include social dumping and regulatory subsidies, raising WTO compliance problem and maybe possible trade dispute. So I want to talk about what is the social dumping and the relationship with the trade remedy. Social dumping refers to cost advantages from weak labor or environment standards. Regulatory subsidies occurs when government fail to enforce this kind of standards. A lot of scholars has argued that such kind of practice should be treated as unfair trade since 1990s, but whether the lack of or poor of enforcement of labor or environment standard constitutes an unfair cost advantage in the determination of the dumping or subsidy has long been controversial, but hasn't been reflected in the practice. So, but recently the United States has started to consider this kind of problem and has regulation to deal with this kind of problem. Under the amendment, the United States, the US DOC, the Department of the Commerce, is permitted to disregard production costs and domestic prices that are distorted due to the lack of enforcement of labor or environment protection. And a lot of scholars point to use the trade remedy mechanism to address the social dumping issue. So it's a kind of trend to connect the sustainability standard into the anti-dumping and the countervailing duty law. This amendment marks a policy shift to address sustainability-related trade distortion through the AD and the CVD. That is a very important thing for our industry because we are the export-oriented industry. In the proposed rule, Commerce introduced a concept of government in action on sustainability standards. Explain that because government in action and the failure to enforce property, human rights, labor, and environment protection lowers the cost of the production for firms in their jurisdiction. So government in action leading to cost saving is treated as a potential market distortion, and the USDOC may reject this kind of distorted domestic prices as the benchmark in the AD and the CVD cases. We can go to directly to the provision of the amendments. If the subsidies provide in the form of provision of the goods or service, the benchmark will be the prevailing market prices. But if the prices are derived from countries with weak, ineffective, or non-existent property, human rights, labor, environment protection, and the lack of such protection will likely impact such prices, the authority may just exclude a certain prices from its analysis. It means that it can use alternative prices to replace the real prices. And when we go to the AD rules, it is related to the PMS. This requirement of PMS means particular market situation. If there is the PMS requirement allow the authority to reject the actual domestic price cost due to the distortion, And the government in action related to the sustainability standard are introduced as example of cost-based PMS. That is say that if the cost-based PMS exists at the import level, the authority can disregard the production cost data of the producers or exporters when determining the constructive value, or say that the benchmark. And this will cause the problem of the WTO consistence because we know the countervailing duty and anti-dumping was also the subject of the ADA agreement and the SCM agreement. So the issue is that can market distortion caused by the government inaction on sustainability standard justify the adjustment of or replacement of actual data or prices under the WTO law. And the key focus is in addition to the authenticity, is there any room to consider the reasonableness or the fairness of domestic market price? This is the key point. And I think ADA, the anti-dumping and the SCM agreement have different regular goal and regular different forms of unfair trade. So we should discuss it separately. About to the subsidy, SCM agreement is also related to the Article 14D. The question is that is there any rooms for the investigating authority to consider or to use the out-of-country benchmark to replace the actual price in the domestic market. And we can see from the case law, the case of U.S. softwood lumber, the AB has supported this kind of opinion. It said that the use of alternative benchmark will be allowed if the market distorted by the government intervention. And I think the benchmark in the Article 14D is a hypothetical price. That means we have to figure out the price without any state intervention. And let's give the authority a space, a room to consider the reasonableness of the prices. So I think the government inaction on sustainability standard may justify the use of the alternatives. However, when we go to the AD, anti-dumping agreement, that's maybe another thing, because although the PMs can justify, reject the distorted domestic prices in the Australia case, but there is still some ambiguity need to be clarified, because can absence of standards constitute a PMS if the exporting country is not even a party to the ILO convention or MEA and has no obligation to incorporate the standards into its domestic law? Can we say that the absence or lack of this kind of standard could be a PMS and just disregard the domestic price? So this problem is quite confused, and we need to talk it later. And go to the cost-based PMS. That's the problem is that in the article, in the agreement, anti-dumping agreement, Article 2.2.1, there are a lot of cases about this article. And in the famous case of the EU biodiesel, everybody have a very clear opinion about the reasonableness of the cost. It said that the reasonable reflect under this article is just refers to the actual cost under GAAP and not the reasonableness of the cost. So that is this article focuses on the authentic of the data, not the reasonableness of the data. So we seems to have no rooms or space to consider if this cost is reasonable or not, if it is real or actual. So the cost adjustment due to the destroyed by the government inaction unlikely to meet the WTO standard in those kind of WTO jurisprudence. And for Taiwan, this kind of amendment would have a significant impact on the Taiwan's industry. As the main targets, as I said, of the AD investigation, legal uncertainty arising from the amendment. This amendment will influence Taiwanese exports, especially in the sector of metal, chemicals, and machinery. This is our main export sector. And the amendment allows cost adjustment due to the government inaction on sustainability standard seems now to punish predatory pricing behavior. That is the origin goal of the anti-dumping, but rather weak supply chain risk management. Why I would say that? Because I can give you the example. Because the cost-based PMs cost the input level distortion. If there is a cost-based PMS in the input level distortion, such in the raw material components or even the energy sector, And the downstream exports is the subject of the AD investigation, may be unaware of government inaction happened at the upstream level. That's to say, failure to identify and mitigate the risk in the supply chain, like forced labor or environmental danger, may lead to use of cost adjustments in the AD procedure and create uncertainty in the legal environment. So, because lack of this kind of due diligence regulation, such as the EU has just passed the Corporate Sustainability Due Diligence Directive, expose Taiwanese producers and exports to sustainability-related risk in their supply chains. Yeah. Oh, okay. So although the voluntary efforts remain limited to some high-tech sector, but the traditional industry are still vulnerable to the AD investigation. So my conclusion or my suggestion is that the exports may face higher duty without effective supply chain risk managers. We have to encourage our industrial enterprise to incorporate the due diligence procedure into their policy, and defining sustainability standard is quite essential for fair trade remedy application. Yeah, we can take the EU CSDAD, for example. And I think the bilateral and the regional trade negotiation can provide platform to achieve mutual agreements on the protection level of sustainability standard and enhance transparency and stability in international. Thank you for everyone.
Okay, thank you, Nan-Hsun. And so after we discuss about the trade barrier and the trade remedy, I think we'll move on to Professor Hsueh's more soft gender issue. Okay, so we welcome the Professor Hsueh to talk about his gender topic. Thank you very much.
Okay, first of all, I will thank you, all the audience. You have given up a very wonderful panels. Personally, I would like to join the other panel because they got the topic that interests me more. First, because I'm a scholar studying both in trade and investment. I know they are very interesting panels. So first of all, I have to thank you to stay with me. And I know 80% of the audience, so which make my presentation more comfortable. Okay. Then the topic is about gender, identifying the missing pieces for deeper gender integration. Especially, I want to criticize the practice of Taiwan. So I see our former Minister Dan sitting there. So maybe you can give me more insightful criticism and observation. This is explaining why in the Taiwan's trade agreements, we've barely seen any gender consideration. And 4 questions is fully relevant. First of all, why Taiwan so special in trade and gender integration? Why we study Taiwan? We got plenty of states. Why this one? And what is special in the context of gender and trade? And the second, what has Taiwan achieved in gender mainstream in trade agreement? I'm just joking that we have done nothing, but actually we have made some progress then in comparison to the global what we have achieved. And the third question is why other gender considerations are marginalized in trade agreements? And the fourth is what are the takeout, what the lessons could be bring to the other states who want to pursue a more gender inclusive trade agreements. Then move on to the first question. everything. Why I choose Taiwan? Not because I'm a Taiwanese, but also the practice of Taiwan, which I find quite interesting. Everything looks great. We have done not well in trade agreement, not because we have done bad at domestic field. Quite to the contrary, we are quite okay in the domestic legal system. We got a very strong internal frameworks, and we got robust gender legislation, and we have an implement act to the SIEL, the discrimination against all discriminations of women, but we are nothing address gender in the trade policy. So the question is, why does the state, with such advanced internal gender equality framework, systematically, but fail to integrate these commitments into its external trade instruments? Is it it's a policy oversight, or is it an institutional barrier, or it's a deliberate choice? So that's the major idea of my presentation. Then, what has Taiwan achieved in gender mainstreaming? That's put in the context. Let's compare Taiwan to rest of the world. And you can see I just categorized the FTA in 4 different categories to simplify different level of integration. The first level is full transformation. I take EU as an example. And somebody will say EU is not trade agreement. No, it was and still is. So the EU simplified a very good combination between the two fields. The EU not only got trade provisions, they also got gender as a human rights. And under the EU, it's under this framework. Both sides are important. The trade agreement should not in any way violate the human rights, including gender equality. So they have certain of incorporation. So I call it full transformation. I think it's not only about trade agreement. It's about the truly trade agreement. And the second level is sustainable integration. These gender provisions grant legal status of gender equal to the trade rules. And some of the EU FTA show these features. And the third level is symbolic integration. In these agreements, the gender has been explicitly mentioned, but their status is somehow inferior to the trade rules, and they include only soft obligations, just like our chairperson just said. It's a soft issue. It's not a hard issue under international trade law. It's like a side agreement or desserts or sort of things. But anyway, we can see more and more FTAs that have incorporated the gender through this way. For instance, like the Chile-Uruguay FTA, CPTPP, and the GATTAGA. It's the global arrangement of trade and gender. And the last level is preliminary integration, which I've said, WTO. The lowest level of integration in these agreements, the gender provisions are not even explicitly mentioned. They are taken as exemptions, or they could be incorporated in the SDGs, the Sustainable Development, and labor, or sort of indigenous people sort of things, or mostly it's SMEs, small and medium enterprises. So that are in these categories. So we got 4 different levels. And where's Taiwan? Make a guess. Certainly between level 4 or sometimes jump to level 2. So sometimes what we have, Taiwan's, we got predominantly very limited or preliminary integration. Most of the Taiwan's FTAs, they are gender blind. We only got 9 in total, and only got 3 or 4 with our major economic partners. Most of them are signed between the developed country because they got official domestic relationship with us. So they mostly did not mention any gender. But we can find some intentions. For instance, the US-Taiwan 20th Century Trade Initiative, they just mentioned slightly within the, again, micro, small, and medium-sized enterprises under the context of SMEs. And other than that, they only give some potential. For instance, we reserve exceptions. This exception could serve as a path for the gender concern to be included in the trade agreement, or you can allow us to adopt gender-friendly trade measures without being challenged. And next, and most of the time, Taiwan, it's not fair to say that we not care about gender at all, but we take different approach. We just take more voluntary and symbolic integrations. We just practice. We just say that if you do not buy me to protect gender, then I will willing to participate. I'm willing to do more efforts. So we can see that we participate in the APEC forums. We're quite active in the APEC forum. We shared our experience regarding gender and development and gender economy, all sort of things. And we also, it's a rumor saying we are quite interested in some global trade and gender arrangement. I don't know. Some would say maybe we got very interesting. And we also very active to put this in the trade policy review mechanism under the WTO. And in doing that, we can, especially we put it in the TPRM, and I have read the reports. We put in the TPRM, then we also encourage our trade partner to raise questions and to discuss about what we have achieved, and sometimes give us some suggestions. So that's the other way we approach the gender issues. But there are only 2 very interesting provisions I have found among the FTAs. These 2 provisions give some, I think, more potential to raise our level straight to the top. So first one is I found the Guatemala FTA. We got some provisions saying that we should follow the constitutional law, the rule of constitutional law in accordance with constitutional law. But our constitutional law saying we should protect gender. So if that's the case, if we somehow breach or if we adopt trade measures somehow infringe gender provisions, so that's the gender rights, so that would be null or not legitimate. The second is the Taiwan-Canada FIFA. That's an investment in this investment chapter. It says the petition for recognize the gender equality as a component of the minimum standard of treatment. So which means the state should, as long as it would involve investment measures, that should follow protection for gender equality, all sort of things. So it's a minimum standard. If we violate them, the investment might can sue us in a way. So that is a very interesting provisions. And what other gender considerations are marginalized in the Taiwan trade agreements? So that's for my guess. I cannot confirm whether that's true or not, but I can do analysis based on our legal and institutional structure. So correct me if I was wrong. We got our former chief negotiator and our former Minister of Economy, so he knows the best. So, but allow me to make some guess. First of all, I think the problem was we just separate the 2 systems. Normally, we got strong and domestic gender legal framework. We got Constitutional Article 9, Article 10, 7, and we got Gender Equality Education Act, we got Act of Gender Equality, and we even got the enforcement of Act of SIEL. How many countries have that? Many countries have signed the SIEL, but did they actually make it a domestic law and really implement it seriously? But we do. But the problem is trade policy remains gender neutral. Why? Because all then I will see, as long as we see the practices, we will find somehow our structure, institutional, give an image to the trade authorities, making sense that it's none of their business, or to imply that they should be a separate policy. So, because, for example, I think our ministry are so reactive to the gender issue because they think it's none of their business. For instance, OTN has never initiated gender provision without external promoting. They did not actually initiate any issues. And they think all the gender issues should be responsible of the GEC. The GEC had a full mandate and authorization, and the MOFA did not, and the OTN did not. They think we don't have authorization, we don't have mandate, because, and the problem is GEC rarely review trade laws and agreements. The GEC is quite active. They review all the policy and laws, and they also issue reports, and they even give a list of laws that violate gender equality. They just throw, okay, we should change these laws, and they post it online. So the GEC has actively to check whether our state has done things right. Okay, again, we got GIA, we got gender impact assessment for every policy, except for trade. Why? Because if you read the laws give authorities a SAS, there's some exceptions for the trade rules, because they said if the policy have to kept in confidential, if the policy have involved some time concerns, which perfectly fit the trade negotiations. So in reality, the GIA, the gender impact assessment, have never been made before trade negotiation. And if it did not do well, then the Gender Equality Commission might not complain. They did not complain at all. And the problem of is legislative limited in role because can I get 2 minutes? Okay. The legislative they should have the chance to participate in trade negotiation, but in reality they did not actively get engaged in the trade negotiation. So that's no way to make more diverse participation in trade negotiation. Again, the inter-agent consultation also include a GEC. According to the sort of domestic laws, the mafia have to consult with a certain the government agency, and they also have to do impact assessment on economy. Again, the GEC was not even included. And the civil and society engagement is very marginal. It's very weird that the gender advocate did not really participate in the trade issues. The only time they participated actively was 10 years ago. There was the Sunflower Movement. That's the only case they got involved. Other than that, they did not make any statement regarding any trade negotiation. Even in the 21st century discussion this time, they did not join the supervision coalition. So, so why we include it? Because our trade partners tell us to. So that will lead the other question, the other problem. If our trade partner did not access to, then we just skipped the issue totally. So I cite some causation between our trade partners and our gender provision. So, to conclusion, what lesson can be taken away for those states we really want to engage in trade, engage in trade agreements? They should prioritize internal institutional coherence and legal integration to make sure that the domestic legal system actually pursued gender policy, and especially a clear and legal obligation and cross-sectoral coordination. Normally in trade negotiations, the trade negotiator and the Ministry of Economy will consult with different interest groups, but the trade group was never in their list. And ensures substantive, not just procedural legislative oversight, especially if the legislative organization have opportunity to join, then they can bring more diverse views on it. Okay, fourth inclusive versus. They also should also include more stakeholders, with also to help the trade negotiator to remind them that it's a trade issue, and avoid so reliance on the external influences. And so that's the problem of current approaches globally. We are saying that if we put in the trade negotiation, if we force if we pursued with some major advocator, then that would help to proliferize the trade provision, but it's not. So my time's up. So that's ends my presentation. Thank you.
Okay, thank you for Professor Chieh's presentation. And so we will discuss later, so please, you can just think about what kind of comment you would like to, or questions you would like to have. So right now we are continuing to have our last presenters and panelists, Hsien, to talk about Taiwan's role in the WTO dispute settlement proceedings mechanism. Thank you.
Test, okay. All right, so since our time is a bit short, so I'll try to expedite my presentation, so I will not be utilizing the whole presentation, but I would like to leave more time for the discussion since we're having so many familiar faces around. All right, so my topic is focusing on a review of Taiwan's dispute settlement participation and see if there's any possible insights that we can derive for the purpose of future dispute settlement reform. All right, of course, for this topic, let me first show you something. So this will be the structure of my original presentation, but in light of time, I will not go through. I'll just focus on two key observations that I have produced through the current stage of my research. Now, one disclaimer is that what you will see here today is research in progress. There may be much more to look into, and I look forward to any feedbacks I can get from today's discussions. Now, let's first look at this. So when I was looking into Taiwan's participation in the WTO dispute settlement, and the WTO website does have a very, very convenient way of accessing these informations, and this is what you can find on the website. So the numbers you can see is the indicative number of cases that Taiwan participated. Now, just to be clear, even for the WTO website itself, it does make clear that these numbers can be a bit imprecise because they list based on case numbers. Now, so when you look into the actual number of, if we say, disputes that Taiwan participate, this number must be adjusted. A number of factors. First of all, some disputes are composed of multiple complainants, so they have multiple case numbers allocated to them. So for example, a lot of these cases like Australia plain packaging, China auto parts, these are cases where you have multiple complainants, but they're essentially constituted of the same dispute. So that should be one of the issues when we look at, when you look into these numbers. Another thing is that bear in mind that at least in terms of what I can observe in Taiwan's practice, when Taiwan serves as a complainant in one dispute, it will also do one thing. It will also register itself as a third party with the other complainant submissions. So essentially, in one dispute, Taiwan is both a complainant in that dispute, but also a third party to the other complainant's submission. Now, my understanding is that there's only two possibilities: either that Taiwan joined the case first as a third party, but then asked to be a complainant in light of the information it received based on Article 10's procedures. That's one possibility. Or the other possibility is that through third-party participation, it ensures Taiwan have access to other complainant submission on the third-party basis. Not the full content, maybe because sometimes there'll be confidential information involved, but at least you can get some information. Now, of course, how this actually works out in the real actual proceedings will require information that is beyond what I can gain access to in terms of public information. But in addition to that, some additional clarifications here. First of all, the respondent number is interesting because this case, which is the recent dispute in terms of the offshore wind farm with the European Union, to my understanding, this case has reached an early resolution after consultation. So whether this actually progressed on to WTA as a formal dispute, which indicates the need for like a panel review, at least in this stage, I think it's not the case. So you can actually argue that there's actually no case where Taiwan has served as a respondent, but you can also say there is in light of the fact that the triggering of consultation is the formal triggering of a dispute in WTO settings. And final point is that I did find one case, which is the Japan DRAM's Korea case. In that case, I have not found any document that indicate Taiwan wanted to be a third party, nor has anything been recorded in panels and apple body reports, but we were listed. I am not sure whether this is a typo or actually we did participate in third party as a third party in some cases, but if I were one listing this case, I would remove that case from this listing. So this is a bit of an explanation in terms of the actual numbers. All right. Now, in light of time, I'll just present two key observations. Now, the first thing that triggered my interest was, all right, apparently we are very, very active on the third-party front, but we are very, very reluctant in bringing a dispute. And also, for some reasons, other WTO members are very, very reluctant in bringing a dispute against us. Do know that Taiwan, in our own domestic measures, we have our problematic measures. These measures are just not being challenged. At the same time, Taiwan is also, a lot of the producers, exporters are suffering from trade discriminatory measures by other WTO members as well. If that is the case, and do know that WTO dispute settlement mechanism isn't that difficult to access compared to, for example, International Court of Justice, why there is this kind of choice to not bring a dispute against Taiwan, but rather rely on other direct means. So, for example, United States, when they are challenging Taiwan's U.S. pork and beef imports, either due to residual chemicals or mad cow diseases, what they do is they exert direct diplomatic pressure. And China is not happy with a lot of our measures as well, and not to mention Japan. So we still maintain some kind of a ban on food products from Fukushima, even though we relaxed it a bit. And that is itself should be a good basis for a dispute, but never was there one. All right. Now, in the case of the respondent one, which is the offshore wind farm, now that case can be argued as an example where maybe Taiwan was not subject to dispute settlement because of our market interest. If there's no market interest in Taiwan, there may be no merit of bringing a dispute. So in the case of offshore wind farm, because the EU takes its wind energy sector very, very seriously, and also observing the possible large markets that Taiwan have, they brought a dispute. But this does not explain why other WTO members don't bring a dispute. If, for example, if the United States is so interested in Taiwan's meat market, why didn't they bring a dispute? This is the case for other WTO members as well. So my take is that, all right, apparently there are some additional considerations that cannot be explained by mere market interest. Maybe there are other non-market considerations involved. And what caught my interest later on is when I reviewed the third-party participations, there are two instances that caught my attention. So there's one instance that is in the the EC Fasteners China case, which is in the panel proceedings, there was this small issue about China having a problem with the abbreviation used by Taiwan in that dispute. They insist that we should use Chinese Taipei, not other short forms. It's interesting because this shouldn't be a big issue, but China seems to take this very, very seriously, to the point that the panel had to record it in its panel report. But since Taiwan and the European Union, they responded in that dispute, didn't raise any issues, we follow their request. Another interesting case, which can be seen, is in the apple body proceedings in Australia plain packaging case. In that case, that is the one instance where I find that the apple body refers to Taiwan, not in its full membership name, but uses specifically Chinese Taipei. This is a deviation from past apple body practices, and in a later dispute, which is in Argentina import measures, they resorted back to calling Taiwan its full name. Now, what happened in between? I cannot find any publicly available information. So from these pieces of information, what I'm looking at is, all right, the consideration of whether to engage with Taiwan in dispute settlement and whether Taiwan wants to engage in dispute settlement, there are some very, very maybe political, diplomatic considerations involved, which my guess is likely involves China. The fact that China is very, very sensitive on cross-trade issues, on Taiwan's status, and the other WTO members, irrespective of its relationship with China, is cognizant of that large pressure in the WTO. Those might have been a possible reason for this lack of activity within, at least in terms of being parties to the dispute. And my take is that this is also a consideration for our government, Taiwan, as well, because if the other WTO members are sensitive about this, we should also be careful in terms of what kind of actions we take. Granted, Article 3.7 of the DSU does say that it's for the WTO members to decide whether bringing a dispute to the WTO is fruitful, but what is important here is, all right, what do we mean by fruitful here? What is the consideration that is affecting the decisions of these WTO members? So what I would take is that this is maybe one facet of the larger issue, which is the concern that certain WTO members might not want to bring a dispute or not engage in dispute settlement, specifically because their actions might offend certain powerful WTO members, even when those actions are legitimate and allowed under the dispute settlement procedures. Another example that is reflective of this is, in my view, the actions of Antigua and Barbuda in response to the US gambling case. Yes, the Antigua and Barbuda gained permission to suspend concessions in respect of intellectual property rights, but they didn't take any actions yet. They're still calling for US to comply with its obligations under the WTO. And the reason why Antigua and Barbuda is a bit hesitant on taking action, for me, is a reflection of that kind of problem. So Taiwan itself, this example, might provide insight in terms of understanding what do we mean by weak WTO member, strong WTO member dynamics? What are the ways to improve the system to at least encourage engaging in dispute settlement without the fear of these kind of powerful economic members? That is something that we can look into, at least. And I think Taiwan's case is a bit reflective of that larger issue, even though it's more on terms of peculiar diplomatic situations rather than saying about market power. The second observation I want to quickly make is that in terms of third-party participation, basically since the DS-399, that dispute onward, Taiwan started to become more and more inactive in these kind of third-party proceedings. We refrain from submitting written submissions, we refrain from making oral presentations, and that kind of trend seems to show in later performances. This is very, very different from the earlier days where we would actively submit contributions in hope that we can provide more insight into the legal issues of the dispute. Now, why has there been this kind of change of attitude? Is something that I have no answer, but from a procedural, WTO dispute settlement procedure perspective, I find that to be a missing opportunity for the WTO itself. Because sometimes when third-party submissions, what they can do is they can provide context to panels and the appellate bodies in terms of to understanding the dispute, not just from the parties' perspective, but from other WTO members' perspective as well. They can help compose a more comprehensive view of the situation and use that as a basis to support their rulings. The fact that Taiwan is become more and more inactive means that we are less going to be contributing to that kind of discussion, which will be a missed opportunity. So for the future of WTO reform, another thing that we can consider from Taiwan's example is, all right, what kind of reform can be done in order to really encourage third-party participation, not just being there and gaining information, but also in terms of participating in contributing to the whole process. So this is what I wanted to say in light of the more limited time I have, and thank you for listening. And I want to welcome any questions you may have in respect of this issue. Thank you very much.
Okay, thank you for Professor Wu's presentation. So now I would like to move to the Q&A section. So I think that I would like to first invite our audience. If any audience would have either comment or questions that would like to ask for our panelists, then you can raise your hand or just speak out your name and affiliation, so let us know. If there anyone would like to share or ask questions. Then our minister, please, you have the floor. Thank you.
Thank you very much, Moderator, Chair. I think this is a wonderful panel, and the topic of the discussion are all covers many issues which are important to our trade policies. So I want to thank you all at my beginning points. Several issues, I think they are excellent. Professor Huang's point that we should establish semi-formal investigation mechanism to investigate the foreign governments' trade barriers is a very good, very good proposal. We don't have it. Generally speaking, business who knows several different situations. One situation, they got foreign governments trade barriers, but they don't want to let the others who know. They think they can solve that by themselves. So they don't want, maybe the concern is they may affect stock price, whatever. The second, they want to be known, but they think government cannot help them. They think politically, Taiwan government is weak, so they cannot argue with the United States, they can argue with China. Most are with United States and China. So they don't risk that. Maybe they just give up that products. Then for those who are willing to tell government, ask for help, you point out the very good point. The government, after handling that, generally speaking, we did not respond to them, tell them the result. So if this semi-formal mechanism can be established, then probably the regulation or whatever establish this mechanism can say government shall notify the complainant within 30 days or whatever its result. So I think it's good. This is a good decision, and also can force the government to really gradually learn that they should very quickly deal with the trade barriers that is established by foreign governments. As to social dumping, I don't know that much, but I think Professor Chang has, you must have your points. Sometimes this is a private business. This is handled by companies, individual companies that dealing with the anti-dumping cases. On Professor Hsieh's point that the gender is not included in most of the trade agreement, I now recall, I think, yes, you are right. It is not there. As to reasons, on US-Taiwan that trade agreement, it is growing, maybe through your efforts or through this type of discussion, we can add that into the agreement. But currently Trump is just put everything Biden did on aside. So there's still a chance, after Trump, still a chance that the agreement can come back. But there's no reason we don't put gender into trade agreement. Taiwan has a very proud record for gender equality. So I think we should do that, and we have every reason to do that, and think our trading partners will respect our request. Professor Wu's dispute settlement, I'll have more comments on that, on this issue. One, the reputation we got in WTO is Taiwan is a good user of dispute mechanism. The reason is we file a case. Your record says we have 8 cases, I think. We file 7 cases. The first case is with against EU. It's not an easy decision. You file against the EU. We know EU legal department, WTO legal department, 35 lawyers. We only have 2 part-time. They are prosecutors. That is the year of 2009. So I remember that case very well. I told those 2 prosecutors, you have to write all our paper. We don't have any budget to hire for outside counsel. So you do all the job. But we are against a team of 35 lawyers. But we did, and we won the case. I think that's really raised our morale on using the dispute. Then other cases as a complainant, then we file against Indonesia, Canada, anti-dumping, Indonesia, yeah. India. So those are in most of the cases, Foreign Affairs, Ministry of Foreign Affairs won't like it. They think the foreign government will get annoyed because we file a case against them. Generally speaking, they will not support it. But trade agency will argue, trade agency, as long as we argue this is a case for business interest, then generally speaking, they will be quiet. The opposition won't be there. So those cases can be filed. And most of the cases we won. The last case is with Indonesia. But at that time, the dispute mechanism pretty much collapsed. So Indonesia thinks they lost the case. We won the case. Again, that the case was solely done by our internal lawyer. We have a lawyer now. He left. he left the trade negotiation office, went to work for Denvaker. We won the case, but Indonesia, then the current situation is you won the case, but they then appeal. After the appeal, there's no appellate body. So in effect, you cannot enforce your winning judgment. The winning decision just set aside. Nothing you can do. So finally, we settled with Indonesia. Anyway, it's not very satisfactory. It's not very satisfactory. But we have tried to utilize the system as much as we can. The issue is this: it costs too much. The outside counsel for a case now is very easily over $2 million US. Very easily. So we have to rely upon the in-house lawyer. In-house lawyer is too much other work. So that's basically the most the weakest issue we have is it costs too much. Costs too much. I don't know how to deal with this. But then the other alternative is you hire more in-house. But in-house won't come. We pay too little. You just cannot. None of you wants to work for government. None of you. We only pay very little. Salary too low. As a respondent, that's right. We try to settle the case. We try to settle the case, and foreign government say why Japanese government did not use dispute settlement to sue us on this Fukushima case. Why they didn't sue us? They have weak case. And maybe it's also, to them, it's the same issue, cost too much. It's to Japanese also hire foreign outside counsel. They don't have the capability to write those papers themselves. So maybe that's the reason. As to United States beef and pork, why they didn't file complaint in WTO on this dispute settlement, I think they can use political pressure to achieve their goal. But their calculation was wrong. It lasts more than 10 years. But again, I think in their calculation, they also think they have weak case. I think it's not very easy. Those people in WTO is not very easy to deal with. You must have very, very strong case. So this comes down to my conclusion. We need more lawyers who can write, and we need more leaders who are willing to challenge the foreign governments and not bend over so-called friend, hurt the friendly relationship with those foreign. Sometimes the foreign governments are not very happy if you file against them. File a case against them, they are not very happy with it. So you must, so first of all, most important, please, you are all professors, teach more good students who can write paper. You need to write very thick paper. And you have to really think thoroughly, very thoroughly, every issues that you put down. So it's very good. This is a very good way to protect Taiwan interest. We should use it to fight against foreign government on their trade barriers. We should use it more often. So my conclusion is, one, thank you very much for everything you comment. I think they are all very useful, very good. If I have a chance, I will convey to my colleagues, my previous colleagues. Please, second, teach more good students. We need them. We need quite a large number of good possible colleagues who can really work on that dispute settlement mechanism. Thank you very much.
Okay, thank you, Mr. Deng's very insightful comment and the encouragement for us to do more. And because there's a couple of minutes, then sorry, you want to have some comment? Yeah, sorry, thank you.
Sorry for interrupting the moderator. I'm asking on behalf of Dr. Brett Williams, who is participating online right now. So the first question from Dr. Williams is, Professor Chan, your research is very important. Thanks for the paper. In A4 paper case, we tried to get panel to find that dumping meant price discrimination and nothing else, but they saw themselves as not needing to decide that. In your paper, you mentioned that the use of PMS was not addressing predatory behavior, but the behavior which the AD agreement addresses is price discrimination, not predatory pricing. The whole context and object of the AD agreement is aimed at working out if there is PD, and if so, what margin. The AD agreement allows cost-based normal value only because it is a reasonable proxy for the actual domestic prices, not other reason. Do you agree the presence of different sustainability standards is irrelevant? It is not dumping, and measures targeting different sustainability standards are not anti-dumping measures. Do you agree? Okay, so this is the first question. And the second question is, Professor Wu, do you think that third parties should be able to retaliate? Okay, so that is the second question. Okay, thank you.
Okay, would you like to have a short, brief response, you two, right now? Okay, you can.
About the predatory pricing behavior and the difference between the predatory pricing behavior and the price discrimination, I think it's just kind of how do you define the discrimination, the price discrimination? Yeah, it is because the discrimination was made by the export, and I think the predatory pricing behavior also made intended by the export. So I just use the term to impress the audience to think about the preliminary goal of the anti-dumping agreements. And about the government in action is relevant to the anti-dumping. Actually, in the beginning, I have agreed with you, with the audience opinion. I don't think they have any relationship because in the anti-dumping investigation, we have to make decision about dumping, which is also only refer to the pricing, the actual pricing, not the reasonable pricing things. So we will not consider about the cost or the price reasonableness of the price or the cost. Yeah, but in the recent trend, I find, and that is not we can against it, because most of scholars in the United States or in the EU or in the Western country, they try to cooperate or introduce the sustainability standard into the anti-dumping investigation. Maybe it's kind of, if you want to use the unilateral a measure to against this kind of, they think it's kind of unfair competition, because your low sustainability standard will attract a lot of our company to your country. Yeah, this kind of attraction, we cannot against it, so we have to find a way or a measure to against it. And the anti-dumping was the only permissive unilateral measure in the WTO agreement. So if you want to use the unilateral measure and which is permissible, I think the anti-dumping will be I can say it's a good way, but it is a reasonable way to use it. Although I'm not so agree with that, but we have to face this kind of tendency. Yeah, this is my answer.
Okay, thank you. So later I would like to have Hsien first to respond, and then each one of you, Huang and Chieh, Professor Chieh, you can respond to Professor Mr. Deng's question overall. So each one of you might have only at least most two minutes. Okay.
Right. So I'll just quickly respond to the online question. Thank you very much for the question. So my answer is that for future WTO reform, I would advise against opening third-party retaliation. The current design of the WTO dispute settlement system is one where, as long as you have substantive interest, a WTO member can join in as a third party. And of course, when we talk about substantive interest, it can be about market interest, but it can also be purely about legal or policy interest. That doesn't necessarily mean that that WTO member has a market interest, but other aspects as well. That kind of setting actually makes the whole third-party proceedings more relaxed and allow panels and appellate bodies to be more open in its management, because there's not too much hooked to that third-party participation. At most, a third party gains access to certain information, and basically that's about it. Third parties are there because they can contribute to dispute, or at least they can gain information. And because of that, panels and the appellate body don't need to have a very, very strong control over who has substantial interest or who doesn't. If we open third-party retaliation, what happens is that the respondents will be very, very stringent in terms of, all right, who do we qualify as a third party? That will actually lead to a significant complication in the actual dispute settlement process, and especially in comparison of the fact that being a complainant in the WTO doesn't really have too much procedural burden. I would rather suggest that rather than opening up for third-party retaliation, maybe it's just better to join in the dispute as a complainant. And for Mr. Deng, I would thank you very much for the insight you provided in there, because to be honest, some of these views is not publicly accessible, so your insight is very, very helpful for my current research. And indeed, I think there's a lot of things I have to consider in terms of looking into this issue. So for example, what are the capacity of the government? And that itself will be one of the considerations. What are the internal dialogues between different departments of the government is also maybe an issue here. And of course, we do not deny the fact that indeed for certain governments, raising a dispute is actually at least a sour relationship between the WTO members. And of course, there's much to have to look into, but at least I hope that what I've preliminarily found through the research of these panels and appellate body reports would at least set up the basis for any future researches on this topic. Thank you very much.
How about Huang, please?
Also, thanks for the comments. And I actually want to, I also want to actually add one sentence, to Hsien's argument as well, that not all the disputes end up with litigation. And I think we do have a semi-structure, or semi-formal mechanism there, the basic system and the frameworks there. I think the importance is really either digitalizations or increase the procedural element and transparent to make it more responsive, and not only to the business sectors reporting those trade barriers, but maybe also horizontally linking other government agencies in that. So most of the trade conflicts can be eliminated at this initial stage rather than going to the expensive and maybe price forbidden process of WTO litigation.
Thank you.
Okay. Thank you for your comment, and I think we all waiting for the new dawn, except without Trump. Okay, so so that's our common hope in trade law, and I think just leave aside Trump, but because we have to do very well domestically, so I think we can be more active rather than just waiting for calls. That's one point. The second point, our minister just mentioned that we need more people engaged in a dispute. Again, I have said we only have to sue a couple of years, only once in a couple of years, so it might not cost efficient to tell students to engage in the trade practicing trade lawyers. But however, if that will be a dispute, I would strongly suggest minister to reach out for the academia group, which we could provide professional services with very minimal fee, or just for, I would say, pro bono services. But anyway, because we like to engage in the dispute, because for practice for us, it's very interesting to see how the dispute engage. And so that would be a win-win situation instead of just to invest big money in the lawyers. Thank you.
Okay, so as a moderator, I really think about Mr. Deng. He talk a lot about his very valuable experience and the comments, so that I do not need to put a lot of questions to our panelists. So I am quite enjoyable for that kind of conversation with you. And before to conclude this section, I would like to thank all the audience. I find that several friends from Taitung Yuan, Li Zhen, and Lun Fan, very good. I love to see you. And final point that in terms of talking about the attorneys, the counselor, right? Here we have the representative of Taipei National Taiwan Bar Association, and actually is a sponsor for part of sponsor donation, a little money for this event. So how about that? Can you give us some comment on the overall theme of the discussion of this panel? Thank you.
Thank you.
1 minute.
Okay. Thank you, Professor Yang. Firstly, I would like to express my sincere gratitude for all the great speeches inspired our legal community so much. And in terms of how to advancing the legal profession, and we, as the chairperson of the International Trade Law Committee, I advanced some proposals for our Taiwan Bar Association. And one of the milestone achievement is to make the international trade law area as one of the specialized area in our legal profession. And there are currently only 13 specialized areas in the Bar Association. So I think this is one of the milestone movement and to advance this area. And maybe after this conference or a lot of efforts by all the professors, we can bring the new classmates to the legal profession, and we shape a new road for the new trade lawyers. However, we are still have a lot of doubts about how to formulate systematic training for trade lawyers and how to provide professional services with minimal costs for our governments. I think we maybe how to cooperate with the government and in terms of how to maintain the strict confidence, strict secrecy for the matter, and how to draft and how to report to the maybe to the president or the more important prominent officials, and how to strike a balance between politics and the laws remain challenges for our legal profession. We really need and want minister and all of our leading scholars to guide us. And maybe we can, maybe in the next 2 years, since I'm still in the term, we can come up with several kinds of cooperation styles, or provide any kind of practical ways of solving the cooperation problem. And I believe that, as I heard a lot of lawyers, they also possess the hearts to be loyal to our country and to provide us professional service to our governments. And so how to have a bridge, and how to initiate new opportunities, or start with what kind of topic. I think everything can be discussed under the guidance of the minister and also from the distinguished scholars just on the stage.
Thank you. Okay, thank you. The lawyer Hsu. Okay, yes, you're a professor. So, we are looking forward to further discussion and cooperation in the future. And I officially announce that we are conclude this section for this panel. Thank you very much, and good afternoon. And I will invite the audience to have a group picture. Photo here, please. Yeah. 照我们讲者先，然后等一下讲者那些。